Hi, nice to meet you to everyone, all the participants of this new first workshop of Trumpet. So thank you, Olena, for being here, first of all, and thank you for all the time spent in creating, organizing this workshop. So just really a brief introduction about what we are going to do in the next 30, 45 minutes uh, within the experience of Trumpet project, which is an European funded project. We decided to create more awareness about all the topics related to Trumpet, which is compliance. And we are very lucky because we have the opportunity to have great professionals from the consortium. And today we have the first one of them, which is Olena Barda from Time.Lex, which is an attorney in law, and so she will help us in understanding something more about the way in which we have to face GDPR managing health data. So again, welcome to all our participants. Thank you, Olena, for this great moment of science and on legal aspect. Thank you.
Okay, can you hear me, right? Okay, good morning, everyone, and thank you so much for joining us today in this workshop. So maybe I already share my screen so you can start seeing my presentation. Just a second. Okay.
So in the moment, just to confirm again that this webinar will be recorded, and so for sure dissemination purposes.
Okay, so you can see my screen, right?
Yes, exactly.
Great. Okay, so good morning, everyone, and thank you so much for joining us today. So we're going to talk about, as Francesco already mentioned, we are going to talk about GDPR, specifically with paying attention to the processing of health data in research. I think that most of our participants, they are researchers, so I believe it might be quite useful. This is the first seminar of the series of seminars, which we organized in the context of the Trumpet project. And my name is Olena Barda. Actually, I work at Time.Lex. And who is Time.Lex? Time.Lex is the legal law firm, which is based in Brussels, and we specialize specifically in IT law, data protection, so on, so on. On top of that, we are also the partner of the project, legal partner of this project. So I would start share. I will start with my, doesn't go in the presentation. Okay, no. Okay, so briefly about what we are going to talk today. We will start with, considering that also we have like very restricted time, I would like to mention that we will not be able to talk about the whole GDPR or like talk about the all topics. However, I would like to introduce you to the most relevant basis of GDPR, specifically considering that those elements that applies to all data processing when we talk about like data processing of personal data, processing of health data, and so on, so on. So we'll start with the GDPR introduction. Then we will talk, of course, about when GDPR applies and how it applies, what we have to consider, specifically data protection principles with the cornerstone of GDPR. We will talk about data protection roles and responsibilities. And then we will have more practical discussion. I would like paying attention and to the health data and research. However, with all the basics, we will not be able to understand and discuss how we should process health data and research. So this is the basics that we talk about today. Also, I will be, if we manage, I would like, to have like Q&A session. However, if we will not manage because the time is really restricted, you will see my email, and whether you will have any question, you can always contact me and to address your question. I will happily reply to them. So let's start with the introduction to the GDPR. I think that GDPR, basically General Data Protection Regulation, is something that you already heard about. This was a very famous word for some time, and specifically it's relevant today as well. So basically, what is GDPR? and I would say that when we start processing personal information, we of course have to consider and to be compliant with law. And the first, our point of reference is General Data Protection Regulation, which is very important because it's applied to the processing of any personal data by all companies, entities located in the European Union, and not also, but this is not the point of today's discussion. It regulates and the principles of data processing, legal basis, data transfer. It provides information duties of the data control, data processors, security obligation, and so on, so on. So this is the first point of reference when we start personal data processing. And the second layer is actually very important, it's national law, because at some extent, national law can also provide additional conditions, requirements, rules to the GDPR, and maybe exception as well, which are very important specifically when we talk about health data processing. We of course, we will discuss it later, but you have to keep in mind that national rules that are additional to GDPR might also be very, very important. So, when we talk about GDPR, as I already mentioned, we talk about the rules for the personal data processing. From my experience, I thought that very often people confuse a little bit when GDPR applies. What does it mean personal data and not personal data? We will discuss it later, but the first thing first, the GDPR applies to the processing of personal data, and it does not apply to the processing of non-personal data. But what is a personal data? What are we talking about? What are those data? When we talk about personal data, first of all, I have to mention that the definition of personal data is very broad in GDPR. So this very broad and extensive definition. And GDPR says that personal data is any information relating to identified or identifiable natural person. When we say identified, it's easy to understand because my name is Olena Barda, and you can easily understand, identify me by my name. But when we talk about identifiable person, it's quite tricky a little bit, and GDPR also provides a definition of the identifiable natural person, saying that this is a person that can be identified, in particular by reference to an identifier, such as name or ID number. I understand this is makes a little bit even more difficult to understanding of identifiable natural person, but what does it mean? And practical example, for example, we have two different pieces of information. When you try to identify, for example, myself, you can have my age. This is just a number. It doesn't say to you a lot. But if you add, for example, my name to the age, or just surname, you can easily identify me, right? So when all these different pieces of information are also personal information. So this is very important because to keep in mind that most information, even the information which you can use and cannot directly identify a person, will be personal information under GDPR. And in this case, GDPR will be applicable. Okay. Then, very relevant topic for us, specifically for this workshop, GDPR highlight one specific special categories of personal information. Why? Because special categories of personal information, it's still personal information, so GDPR will be applicable in this case, but they highlight it because of their sensitive nature. The following categories of personal data are special categories of personal data, so data revealing racial or ethnical origin, or political opinions, religious, philosophical belief, or trade union membership, data concerning a natural person, sex life or sexual orientation, and of course, genetic data, biometric data, and health data. So I think that's important to keep in mind that when we talk about health data, we talk about special categories of personal information. Why they're highlighted, we already mentioned, because of their sensitive nature, but on top of that, GDPR said that the processing of these categories of special categories of data is in general prohibited. However, then it lists the cases when the processing of this personal information is allowed. And of course, I think that we are considering we are researchers, many of them are us here, scientific research in one of those cases when you can process special categories of data, health data in this case. On top of that, the GDPR requires a high level of protection when you process, for example, health data, specifically by adopting the specific organizational technical measures and on top of the compliance with all other GDPR requirements. GDPR, of course, provides also the definition of health data, saying that health data is the personal data related to the physical or mental health of natural person, including the provision of healthcare services, with relevant information about his or her health status. Okay, as the next topic, we will talk a little bit about the pseudonymization and anonymization. Specifically, why it's relevant to talk in this context about the pseudonymization and anonymization, because those are two techniques mentioned in GDPR in first place, and also they help the understanding of the difference between the pseudonymization and anonymization will help us understand when we have to apply GDPR or when GDPR will not be applicable. So, what is a pseudonymization, and also the definition under the GDPR, the definition is provided. This is process where the personal data can no longer be attributed to the specific data subject without the use of additional information on top of that. And also this additional information should be kept separately from the other information. But what is the main characteristic of the pseudonymization? This is a reversible process. So here we have an example when you switch, for example, the name, replace with a pseudonym or nickname or something like this. This is considered to be personal data. And what is the difference with anonymization? Anonymization is considered to be irreversible process. So in case of pseudonymization, you can de-identify personal information. In case of anonymous data, it's considered that you cannot de-identify personal data anymore. And what is the important point, when we process pseudonymized data, GDPR will be applicable. Instead, when we process anonymized data, it will not be applicable anymore. However, it's also very important to point out that in practice, because considering the guidelines from the different authorities, considering like the long discussion, considering the opinions and decision, the distinction between, when you talk in practice, it's very difficult to achieve anonymization, and the distinctions, the line with distinct them, it's very, very broad very often. So you also have to pay attention in this regard, because when discussing with data protection authorities, if it's very difficult to find, the agreement with them when we agree with them when we have the pseudonymization and anonymization. So, but you can keep in mind that when we have pseudonymized data, GDPR will be applicable, and you will have to apply the GDPR and requirements and rules. In case when you have anonymized data, GDPR will not be longer applicable. Okay, the next topic we are going to talk about is data protection principles. Why it's important to talk about data protection principles of the GDPR? Because data protection principles is cornerstone of the whole GDPR. Most requirements and rules in the GDPR, they are built around the data protection principles. And you, of course, when you process personal information, and since the beginning until the end of the processing of personal information, you have to keep them in mind, and you have to comply with all of these principles, GDPR principles. So what are those GDPR principles? We have 7 key principles: lawfulness, fairness, and transparency, purpose limitation, data minimization, accuracy, storage limitation, integrity and confidentiality, also known as data security principle, and accountability. And let's see a little bit more in detail what we are talking about. When we talk about lawfulness, GDPR requires you, when you process personal information, to rely on a specific legal basis under GDPR. For example, the consent, performance of contract, legitimate interest, and so on, so on. So you cannot process personal information if you don't have legal basis to process the personal information. Fairness requires that us to provide the information about processing operation to the data subject and the goal of processing information. Transparency requires you to share the information with data subject about the processing activities, specifically in a very easy, accessible way and the understandable language. Purpose limitation. Purpose limitation is very important, specifically when we talk about processing of data in research. Later we will see why, but I would like to ask for your additional attention in this regard, because purpose limitation requires us to define the purpose of processing before we start the processing of personal information. The purpose should be legitimate, explicit, and specific, and also we cannot process personal information for the purpose we have. However, this is an interesting point because the GDPR allows further processing of personal information for scientific research purposes. And I think this is also we are lacking this because, and we will understand later, because GDPR pays a lot of attention to the research and to help researchers actually to use the personal information. Data minimization. Data minimization means that we have to process only the relevant, adequate, and necessary data we need for the purpose. And also this information should be kept as little as possible. Accuracy simply means that you have to process accurate data, and also when the data is kept up to date with data and the data is not accurate, you have to make this data to ensure that the data is accurate. Storage limitation, when we talk about storage limitation, it means that we should not process, personal data must be kept in a form that permits identification of data subject for no longer than is necessary for the purpose of the processing. Integrity and confidentiality, also known as data security, requires us to process the personal information in secure and confidential manner, considering also that you have to apply the appropriate technical organization measures in order to ensure the compliance with this principle. And last but not least is accountability. It said, why accountability? Because it said that when you process personal information, you have to comply with all principles that we mentioned before, and also you have to demonstrate the compliance. What does it mean? And how to achieve this, how to achieve this demonstration of compliance. The best way is to document all actions of the processing. For example, you have to have a privacy policy, written privacy policy. When you require the consent, you have to show and you have to the proof of the consent, and so on and so on. So this is so I would like to point out once again that those principles, you cannot ignore them when you process personal information, so please keep them in mind every time, and you have to ensure the compliance with these principles throughout the whole processing period. The next very important topic that we are going to discuss is roles and responsibilities under GDPR. Why it's important to understand? Because under GDPR, if you process personal information, you will have a role, definitely. And correct identification of your role in the processing activities, it's very important in order to understand your responsibilities and what rules should be applicable in your case. So in GDPR, I would say that we have two main big categories of different actors. First category is controller and joint controller, and the second one is processor. So who is controller? Controller is a responsible entity under GDPR and data protection law. And how to identify who is controller? Controller is someone who decides the purposes and means of data processing. So basically it means that controller decides what data will be processed, then how we will process this data and for how long, and so on and so on. When we have joint controller, we have here in this case more than one controller, so two and more. And in this case, they together decide the purposes and means of the processing. However, there are a few additional requirements in this case. The relationship between joint controllers should be regulated by the contract. They have to divide their responsibilities between them, and also they communicate the essence of their relationship to data subject. When we have processor, we have someone who processes personal information on behalf of data controller and acts under the control instruction. So basically, we have someone who does not decide the purposes and meanings of the personal data processing. So when it comes to research, you will have different scenarios of different actors involved. There could be one controller, there could be two and more controllers processing the personal information for the research purposes. You might have also sometimes a controller-processor relationship. So please, in research, pay attention to this. Of course, if you need help, require the help of your partners and so on, so legal partners, in order to define the different roles, because sometimes it's not actually very easy to understand the first point, but then it's very important because it will, on the definition, identification, the correct role, the rest will be the rest of rules and requirements will depend. So it's very important to you to pay attention to this. And we go to the next slide to understand a little bit the difference between them and what they do. So basically, as we mentioned already, the controller is a responsible entity under GDPR, and it's responsible and it must ensure the processing of personal information in correct way, in accordance and with compliance with GDPR principles. It should ensure provide information to the data subject and ensure that the data subject rights are respected. Also ensure the exercise of those data subject rights. It should carry sometimes the data protection impact assessment, and also should respect and should adopt the necessary technical and organizational measures required for the data processing. From the other hand, the data processor is someone who processes personal data, as we already said, on behalf of data controller. Most of the time, it's going to be the third party external to the company. However, not in 100% of time, but most times that we have the third party that process personal data on behalf of controller. What is required? Controller and processor, they must to sign the data processing contract between them. They have to include the duties and responsibilities inside this contract. And also, data processor should process personal information only under instruction of controller. So keep this in mind, because if the processor process personal information outside of the instruction of controller and outside of the duties and responsibilities that the processor has, then the processor will become the controller for the processing of personal information. Okay, and here I think that we arrived to the very important to all of us the topic, health data in research. And I think this will be a more practical discussion. So I don't know if we can also allow people to participate in this. I don't know, Francesco, can we give, if people would like to, because I would like also to.
Yeah, to change it. I saw if there is any comment on question, but there is at the moment no.
Okay.
Left hand, so I think we can just finish the second part and then we can collect all the questions and so move for the discussion, the last part of the workshop. Is it okay for you?
Yeah, perfect. By the way, if you, here we have this part, I would say this would be more practical discussion. And this part, we will summarize all information we already discussed. I presented to you all our knowledges. So if I would like you to invite also to participate, don't be shy.
Yeah.
And
so if you want, just raise your hand and we will allow you to speak in the workshop. So
perfect. So we have health data in research. When we talk about health data in research, we will have two main cases. We will have research as a primary purpose of the personal data, And then we have the research as a second purpose of personal data processing. So let's start with the first case. And I would like to ask people what does it mean, the research as a primary purpose of personal data processing? Do you have any ideas? I know I will give like a few minutes, 1 minute to people if they would like to provide any information and give any example. In this case, otherwise I will go ahead. Do we have, Francesco, someone?
Yeah, I'm just looking to the participants. So yeah, okay. There is also. If someone raises your hand, I will tell you.
Okay, so I think that we don't have an example here. So what does it mean, the research as a primary purpose of the personal data processing? It means like just when you collect personal information directly from the data subject for your research. So basically, for example, if you have research and you're starting the research and you need personal data, then you go to the data subject, to people, for example, and asking them to provide a kind of survey, to reply to your survey, and so on and so on. In this case, we have the primary purpose of personal data processing. And so basically it means when you collect your data for research directly from individuals. The second case we have is the secondary purpose of the personal data processing. In this case, we have the collection. We don't have the direct collection from data subject, but we use the information from that was collected for other purpose. And I think this is important, I think. So our purpose of processing is the research. But the first and initial purpose for the processing was a little bit different. In this case, we have like, in this case, we will discuss it later, but keep it in mind. The first case, when we have we collect personal information for research purpose. The second case, when we use the information that was collected for different purposes.
So basically, Olena, just making a comment on that, I'm thinking about the online repository where researchers collect data, and for example, the TCGA portal where are uploaded all the data of genomic analysis. So basically, this is a case too, a secondary purpose of collecting data. Am I correct?
I mean, it depends because if you collect the thing that if you collect personal information from data subject, but then you put it somewhere, it's like primary purpose of the collection, and you sharing the information, for example, with your colleagues, with the partners, and so on. So this is a primary purpose. But then, for example, if you start your research and you use the information collected by hospitals, for example, this is a secondary purpose collection. Because the hospital, they collect the information, from the patients, from individuals in order to provide the services like in the hospital and so on and so on. But then like provide the cure to people. But then you will ask hospitals for that personal information in order to conduct your research, right? For example, if you have the Horizon project research and you don't consider to collect personal information by yourself, but then you will ask the hospitals to provide the information, health data in this case. This is a secondary purpose of processing. So I don't know if it's clear now.
Yeah.
Okay, great. Do we have any comments from people in this case? Anything?
No, I don't think anything at the moment.
Okay, so let's discuss the first case. The first case is when yes, I think it's perfect. Okay. The first case, as we said, when you collect the personal information for research purpose. And let's talk about the health data in this case, because our workshop is dedicated to the health data. We already mentioned that health data is special categories of data. That means that GDPR prohibit, in general, the processing of health data. However, it lists 10 exceptions. We can call this exceptions. It's a correct term under the GDPR, or cases when we are allowed to process this information. So basically, and as already mentioned, we are lucky in this regard because scientific research is one of the cases when you can process personal information. So basically, this is the first thing to understand. So if you are conducting research and you do need to process health data, you are allowed to do so under the GDPR. On top of that, what should be the next steps in order to start the processing of the health data? You have to find a legal ground for data processing, which I already mentioned that this is one of the GDPR principles. You have to identify what's going to be the legal ground of processing. Most of the cases, and very often for research, is the consent. However, it's not the only one legal basis possible for processing of health data. So keep this in mind. Then you have to add additional layer of protection. You have to consider what would be what are the necessary safeguards you need to adopt in order to keep the information health data safe and confidential. So we have the suggestion in this case from the GDPR. This is a pseudonymization. It could be one of the techniques to process the security of your data. However, you can find more suggestions very often in national law, so please consider them also to consult them. And on top of that, and this is very, very important when you talk about the health data processing, specifically in research and so on, it's very important to consult national law in order to understand if you have any specific conditions, rule, or restriction for data processing. So please keep this in mind and check the national regulation when you have to process health data. Okay, do we have any questions here from people?
No.
So it's amazing. Everything is very much clear.
Yeah, can I tell you that I have people that are texting me on WhatsApp and saying that it's very clear and they really appreciate. So
okay,
I can give you this feedback.
Yeah, was the goal of this workshop, to make it very clear, because that's why I didn't want to use a lot of terminology and difficult words to explain, because I already understand this is not very easy, and to understand specifically people from not legal field, who does work with this every day. So yeah, let's make it so the goal was to make it easy to understand, and to provide you at least the first steps that you have to keep in mind when you start the research, and specifically research and using the health data, because there is actually the difference between the personal data and health data for this reason. But this is the workshop is concentrated on we talk about the health data, so we provide the steps for the health data. Also, another remark, what I would like to add about the national law, that's maybe it's not the best news, but when we talk about additional rules and for the health data processing in research and in general health data processing, different countries, different European countries, of course, GDPR is the point of reference, but I'm pretty sure most of your countries where you live and you process personal information will require additional, will require application of additional rules and additional conditions for the health data processing. And unfortunately, they are not all the same in the around the European countries. Okay, and then we have the second case, and we already mentioned the second case when we process personal information for the secondary purpose. We already said this is we use the information that was collected for another purpose, but we use this information and process this information for research purpose. I would have to say that the secondary purpose processing, when in practice, it's very hot topic in the legal world, and also when it's come to the secondary purpose processing of personal information, because in general, GDPR does not prohibit this, but then you have, there are many different issues to take in consideration. But I have to say that also in this case, we are lucky because GDPR allows the processing, the secondary purpose processing of personal information for research purpose. I think, yeah, there are like a lot of processing and purposes. So you have to keep in mind that as we already mentioned, you have the personal information collected, for example, by hospitals. You ask hospitals to collect the personal information, to use the personal information they collect for your research, then you are allowed to do so. And very important thing that you don't have to ask for additional, you don't have to provide additional legal grounds for the processing of this personal information. What does it mean? For example, you don't have to ask for the consent of the data subject a second time, for example. But what you have to do and what you have to keep in mind and what you have to ensure that the legal ground for the primary purpose of processing is valid. For example, you have to ensure that hospitals have the legal ground for the processing of personal information they collected. This is very important because otherwise the processing for research will not be legal and will not be compliant with GDPR. Then you also, of course, have to, in any case, have to consider what technical and organizational measures you will need to adopt in order to ensure the security and the confidentiality of personal information. The GDPR, the only example GDPR provides is a pseudonymization. However, I think that many different data protection regulation, national data protection regulation, they provide additional suggestion in this regard that you have to keep in mind and to consider. Normally they're not mandatory, but it's best to consider and to apply them. And also, and once again, you also have to check the national regulation in this regard, because national regulation will definitely ask you for will provide additional requirements and will ask you to provide and to add additional layers of security very often. So I would say this is the last slide of our presentation, and I think that we made it very much on time. So here we have the two cases, and I would say that if you have any question about these cases,
we have a question by Ruben, and so I let you to take the question.
Yeah.
So just a minute. And at the moment we have a question from in the chat. I think you can see while I'm trying to allow Ruben to speak, so you can see from the chat, I think, Olena.
I know I don't.
I have a question. I can read. I have a question regarding the GDPR and the anonymity. The use of hash algorithm would be enough to protect data. What is your opinion?
Okay, I will share with you not my opinion, but because it's very tricky. But we have I think the Spanish Data Protection Authority guidelines on the use of different techniques of the pseudonymization, anonymization, and personal information. And under the Spanish Data Protection Authority guidelines, hash is considered to be the pseudonymization technique. So it's not considered to be anonymization technique. So when you use hash, you have to consider to applying the GDPR requirements. So this is what they say. But as already mentioned, the pseudonymization, anonymization, it's really difficult topic and really difficult discussion nowadays, and you always have to consider case by case, because we know that very often the technology evolves much more faster than law, and not often but always. So very often the law it's not easy to find the proper answer. So I would say what you have to do is, first of all, you have to consider to consult, if you have the possibility, the legal people, in order to assess case by case the specific case of the technique that you apply. But now, in general, what we have to say that under the different decision and the guidelines of the Data Protection Authority, hash technique is not considered to be anonymization one.
Thank you very much. There is another question from Jose, and then he says thank you for your workshop. Currently, we work with sensitive medical data, audios and video, and we are dealing with many of the aspects you have mentioned. Thank you very much for the information. I would like to inquire about the data elimination phase and the possibilities of storing representation derived from the data that would allow us to continue working and share them with the community. For example, deleting capture radius, but releasing representation like X vector with the community.
Maybe I have to read it by myself. Because
okay, I think you can open the chat wherever you will see.
Okay. Yes, I have a chat currently now. Okay, thank you more.
So if I understand correctly, it's more related to communication things and health data, medical data.
But what do you mean with data elimination phase?
I know if Jose, Jose, who wants just to speak and comment on that, if you're able just to maybe give you the word. Yeah, okay.
I think that I stopped sharing, right? Okay. Yeah, if you,
Jose, you have this microphone.
Okay, hi. Thank you very much. We are concerned about the data elimination when we finish the project and we are working and we have to delete all the data captured that is sensitive. So for us, it's complicated because we want to publish and maybe keep working with that data. But given the data protection, we have to erase all the data that we captured. But it is possible under this regulation, keep with the data in our servers in a transformation or in any kind of form that could be not biometric value for the project. I don't know if I.
Yeah, I understood. So basically, okay. So first of all, I would suggest you when you start for example, when you draw the contract, you have also, it would be useful for you to in the contract to include the period of time after the project that for which when you can continue to process like the personal information. Of course, as we already mentioned, if in your contract it's included that you have to eliminate the data, so it's very little you can do. You can make them anonymous, so you have to they identify personal information. So this is, I would say, the first thing that I have, like the first suggestion I have for you. However, you really have to to see case by case, because sometimes you have to read the contract that you have for your research contract. If you have, so there are many details that should be considered in this case. But of course, is the main thing, if you want to, you have to make the data anonymous somehow, so they identify like the personal information. In this case, you can continue to use them, but otherwise you have to keep to consider case by case what you have to do. So it's really depends.
Thank you, Olena, and thank you, Joseph, for the question. Now, Ruben, I think now you have the opportunity to talk with Mick. Try again. I'll send you the mic activation. I don't know if you saw it. If not, you can write your question. So probably there is some issues about.
I think it doesn't work.
Yeah. Okay, it doesn't work. So if I give you the, now I try to maybe.
Francesco,
Okay.
can you hear me?
Okay. Echo.
Yeah.
Yeah.
There you go.
Thank you.
It came kind of late. Thank you very much for organizing this, Francesco. This was very, very educational for us,
Thank you.
especially for the guys working with data, but not so much on the clinical side. So my question is pretty straightforward, Olena. Thank you so much for your presentation. I am wondering if you can elaborate a little bit on the legal ground that is required to do these secondary studies based on data that has already been, let's say, exploited by a primary study. Like, I'm thinking about projects like if we want to access electronic health record data from a hospital, what should we put forward with that hospital to have access to that data?
Okay, so first of all, why you would like to accept the personal information of the hospital? What is your purpose? You have to understand. Is this your purpose, the research?
Yes, sorry.
Okay.
I wanted to be brief on the question. Yes, this is
Yeah.
all for research purpose. There is no commercial venturing here. It's just research and trying to help them and use computational techniques to personalize treatments, let's say. So they have a set of data in terms of electronic health records, and they say, well, we want to share this with you guys so you can do something with it. So my question is, like, when you mention the legal ground that needs to be put forward, can you elaborate on that, how that will look like?
Okay, so basically, if you, for example, you have the partnership with the hospital, your research project or your researchers, and you need the data, you have the partnership with the hospital, and the partnership, the hospital give you the green light that you can, they will share with you the personal information. So we have, in this case, as already mentioned, the hospitals collected the personal information for their purposes. You asking for personal information from hospital for your research purpose. And at this point, it's okay. You don't have, when we process and collect personal information, what we have to do, we have to find the legal ground for the processing. What does it mean? Normally, and the most common example is the consent. So basically, a patient comes to the hospital, and hospital need the personal data, and they ask for the consent of the data processing. And this is a legal ground for the processing. For example, the consent. I think this is the easiest example for everyone. So we have the legal grounds for the processing and the consent, and this is okay. Then, and the hospitals legally have the legal ground, so their processing of personal information in this regard is legal. Then you come to the hospital and you ask for the data, for the patient data for your research purpose. This means that you process personal information for the secondary use, for the secondary purpose use. In this case, you don't have to go to the data subject and ask for the consent for your research processing. Mm-hmm. It's not required in this case. But you have to ensure, and maybe in this case, if you have legal people in your research project, or you have to ensure and ask the hospital what is the legal ground of their processing. For example, you can ask, do you have the consent for patient for the processing of the personal information? Because normally, of course, I mean, hospitals will have legal ground, but you have to ensure, and it's your responsibilities, that the legal ground is valid, that the legal ground of the processing from the hospital is valid. So this is the thing. Normally, you go to the hospital and you ask, what is your legal ground for processing this is the consent, this is performance of contracts, and so on, so on. Very often it's going to be all the consent, and maybe you can ask for additional, information, for example, for additional documentation in order to have the confirmation that their legal ground for processing is valid. Because if they do process personal information without the legal ground, your processing will be also illegal, even if it's research purpose. So in practice, what you do, you have the partnership with the hospital in your case, and you simply ask hospitals, do you have, what is your legal ground for processing of personal information of patient, of the data subject patient personal information, and maybe they can share with you an example of the template they use of the contract or consent form, and so on. So it's a little bit like, I don't know, it's clear now.
Yeah, much clearer. Thank you so much, Olena, again. Thank you, Francesco, again, for organizing.
Thank you, Ruben. Again, thank you very much, you too.
Okay.
Okay.
Any other question?
Yeah.
I don't know.
No, at the moment there is no any raised hand. Maybe I can just have you ask you a question related to the how to approach, because you for sure you mentioned, I also refer to the first part of the general overview on the GDPR, and I can also I image a scientist, a researcher, a physician that maybe it's completely not he doesn't know anything about this kind of field. So in your opinion, what do you suggest, what could you suggest us how to proceed in this field to collect more and more to be compliant with the GDPR in starting this kind of a new research related to data? Because maybe there is some hospital that haven't so structured legal office or someone that can help in this kind of activity. So what can be your suggestion of that?
Yeah, thank you, Francesco, for this question. Okay, the easiest one would be to find a legal partner.
Yeah.
Yes, because because there are many details, to if you don't know anything about the GDPR and data processing, so it's complicated. The second one, of course, like to start, to if you like participating in workshop like this, which already give you a little bit of information, of course. And also if you have partners with legal departments, to rely on them. Because just honestly, I think that, of course, I'm a legal person, but when I work with different people and from my practice, I think that all these details is really difficult for not legal people to keep in mind and to understand all legal steps. So yeah, I would say that the best way would be to find support from somewhere. Because, to draft, to consider privacy policies, to consider all the legal details, and so on, it might be very complicated. So, I mean, don't be afraid to ask questions if you don't understand something. I think that data protection lawyers, and they specifically who are involved in the research project or any project, they're very happy, like when people do take in mind the GDPR. Because it's for us, I mean, maybe we live kind of in a bubble. The GDPR is like the most important thing, but of course, for not all people, they do keep in mind the GDPR. But don't be afraid to ask questions, and try to find someone who can support you and help in this. I would say yes, just to rely on some support.
Thank you very much, Olena. So I think we can just reach the end of the workshop, and I would like to thank you for your presentation, for all the concept you share with us. I would like to say also thank you to all the participants and all the consortium of Trumpet that help us in creating this one. This is the first one of, as also Olena told us of the list of a series of workshops. The next one will be in December, and so please join our newsletter. It's a tool that we use for promoting all the information and disseminate all the information about the project, and for sure also have a look of our website, which is a trumpetproject.eu, and so we are uploading all the material and all the things we are doing for the project, and so for implementing also GDPR attention in all the European community. So again, thank you very much for all the attendees, and thank you again, Olena, for being today with us.
Okay, and just maybe the last remark. Thank you very much to you, Francesco, for organizing this, and thank you very much for all you who attended this workshop. I really hope it is useful for you, and you can use some knowledge from this workshop. If you have any question, you can always contact me. I think that you can see my email there, and I will be glad to reply to you and help you supporting and reply to your questions. So thank you so much, and yes.
Thank
See you. I hope to see you soon.
See you. Bye-bye. Thank you. Bye-bye.
Bye.